The estimated my pace. I type using one finger, like Professor Wajakoya. Type using one finger, like Professor Wajakoya. Like Professor Wajakoya. Huh? Huh? Second, second, it was submitted that the public safety. Second, it was submitted that the public safety dictates that the first accused is denied bail or bond.
once again, they've bottled the league. Until next season, cheer up with CJs.
Any offense shall be granted bail unless the court is satisfied that the person A has previously been granted bail and has failed to surrender to custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he would fail to surrender to custody. And B, the last condition, should be kept in custody for his own protection. In my mind, therefore, I entertain no doubts that any accused post the 2010 Constitution, notwithstanding the nature of the offense, is entitled to release on bond or bail, save where the DPP adduces facts and evidence constituting compelling reasons. Their prominent divergency from the repealed Constitution is that the Constitution of Kenya 2010 now enjoins the court to strike a balance between the rights of the accused and those of the victims. I'm skipping some parts for your own reading. I have cited several decisions in line of that principle of a delicate balance between the competing rights. I've also considered the bail and bond policy guidelines of March 2015 and the construction assigned to how that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. So I have also discussed diverse considerations in decisional law and diverse grounds in decisional law, most of which I will not read one after another. I will skip to the standard and proof. What then is the standard of proof? And how should compelling reasons be presented? In Java, against the Republic, reported in 1973, staff reports, page 39, it was held that in opposing applications for bond, that is the Court of Appeals saying, based on grounds set out herein above, it is not enough for the prosecution to make their objections and insinuations. It was underlined that the said objections should demonstrate how release of the accused will be detrimental to justice by being supported by cogent reasons and facts. The decision to grant or refuse bail is only based on probabilities and not certainties. The standard of proof, therefore, is on a balance of probabilities, as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds that advanced in support of the objection to bail upon in the context of the four discussed statutory considerations, grounds plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offences unpersuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and experts can be addressed using alternative means in view of the drastic step of denial of bond. Therefore, this court reaches a conclusion that the state has failed to present compelling reasons to deny the first. Question B. The evidence which was gathered from the first residence situated in Milimani area within Kitale was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the back in a manner stripping it of the manner of pleading such questions as enunciated in the Locus Classicus and Narita Karimu case, a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a litany of cases. Further, this is a question capable of determination in another forum, separate. Disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. A. That pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B. That the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail with the sum of Kenya shillings 500,000 and providing two suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C. Upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Number 1, that the first accused undertakes not to interfere with witnesses and or evidence. Number 2, in order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3. That the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4. That in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5. That the first accused undertakes to appear before court as and when required. Roman 6. That the first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention or hearing unless exempted from attending court physically. Roman 7. That in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8. That in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9. Roman 9 is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision that can be read by yourselves. Roman 10. That all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11. That the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12. That the first accused is one against offending the subjudice rule. In this connection, except in the court proceedings to ensue, the first accused is warned against discussing in public, including in or with the media, the merits or otherwise of this case. D. That the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond of due terms, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned date. In this regard, the prosecution shall be pleased to have complied by doing the following. A. Any tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination in chief. B. Any preparing a bundle of documents binding serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle describing each document, originating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C. The number of documents cannot be in one bundle. The prosecution is at liberty to serialize them into volumes. D. The prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E. The prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F. All copies of the tabulated list of witnesses case the same bundle of documents held by all parties shall be identical to the originals held by trustees. Very finally, this matter is allocated on board number 4 for further directions, clearance, and determination. This connection you mentioned before board number 4 on 3rd June 2025 at 9:00 a.m.
Okay, that's me having the worst day ever. But then I saw them and I knew my besties were both going through it, and that's when I had an idea. That's OT. The socials are having him right now. But not for long. Hey, look at him go. Go, bestie. And that's Chico, certified stress girly. And hey, hear me out, goated producer. So we get to the spot, and what do these guys do? And just like that, I was having the best day ever. Sharing a Coke with my faves. Who will you share a Coke with? On Power Talk this week, we're speaking with Safaricom CEO Dr. Peter Ndegwa. We're taking a look at their results, what has been a milestone year for the company, and he's here to speak with me on that. Thank you, Peter. It's always nice to speak to you.
Nice to be here.
Good. Let's talk about this year. Milestone year. We'll get to M-Pesa at 18, Safaricom at 25 in a moment. But some impressive numbers that you've posted